25th March 2023, in a very important judgment by the single bench of the Karnataka High Court in Basangowda's matter, a important issue and the precedent is laid down under section 15(2), inheritance of a Hindu woman subsequent to the partition of the family property, that is wife's parents' property was partitioned by oral deed and it was recorded in the memorandum. Now the wife died and issue came up that who is the real successor to the wife, because the couple did not have any child. So Karnataka High Court has held, once there is a partition and the properties have been divided by metes and bounds, it becomes the absolute property of the such sharer. If the sharer had any surviving heirs at the time of partition, the property may become joint family property of the acquirer and his family. Therefore, the plaintiff who died cannot be construed to convey the property by way of inheritance at any stretch of imagination. Further, the High Court further recorded and that the courts below did not critically examine the provisions of section 15(2) of the 15 subsection 2 of the Hindu Succession Act vis-a-vis the memorandum of partition. They went, the court said, and it is recorded, they went under the presumption that a partition deed does not create the rights, but it only recognizes the inheritance of the property. The inheritance of the property need not be by the metes and bounds, and only the rights are inherited. If it is testatorily disposition, in whatever mode it may be, it overrides the rule of intestate succession, and therefore the impugned judgment is not sustainable in law. So appeal was allowed, and it was declared that plaintiff to be the owner of the suit scheduled property, and consequently defendants are restrained from interfering in the possession and enjoyment of the suit property of the plaintiff, that is the husband of the deceased sister. Now this is case title Basangowda and Muddogowda and others.